On for preliminary hearing, a request is noted and entered for the record. As to bond, Mr. Binger.
Your Honor, the state is going to ask that the court set bond at $2 million. That is the amount that Judge Wagner set on the arrest warrant in this case. I believe that this court should honor that amount. There are numerous very powerful and valid reasons why that is an appropriate amount in this case. The defendant is charged with 2 counts of first-degree intentional homicide, as well as other very serious felonies. 2 people were killed in this case. These charges are as serious as we get in Wisconsin. There is a certainty that if the defendant is convicted, he will be sent to prison, and a strong likelihood that he will serve most, if not the remainder of his life in prison if he is convicted of these charges. Thus, a substantial amount of cash bail is necessary because someone who's facing these types of charges has the strongest possible incentive not to return to court. I would note that the defendant does not live in Kenosha, does not reside in Wisconsin, and other than a part-time job as a lifeguard, doesn't appear to have any ties to our community. He resided at one point in Antioch, Illinois. However, it's my understanding that the residence or the address that his family resided at, they no longer reside there, perhaps due to some threats or concerns over their safety, but I don't know what their current address is. I think that they are, perhaps for good reason, not sharing that address, but nonetheless, the fact of the matter is if the defendant's released from custody and joins his family, it will be at some undisclosed location. So that is cause for concern. We extradited the defendant from Illinois over strong objections from the defense. There were multiple hearings in Lake County as recently as Friday, in which the defense had filed numerous motions and arguments challenging this case and challenging Wisconsin's right to extradite the defendant. I take that all to mean that the defendant doesn't want to be here and if released won't come back. So I think that that is something the court should consider very seriously. The defense will suggest that the defendant turned himself in on the night of this incident and therefore is not a flight risk. I would suggest to the court that the circumstances have changed substantially since the defendant did that. At that time, perhaps he had the mindset that he was justified in what he was doing, that the police would hear his explanation, give him a pat on the back, and send him out the door. Clearly, that's not what happened. Clearly, he's facing serious charges in this case. And whatever his misguided or unreasonable expectations were that evening when he turned himself in, do not apply any further. We are in the midst of a very serious case here. The court, Judge Wagner, has already set $2 million bond. I think that's an appropriate amount, and I would ask that the court honor that. In terms of the non-monetary conditions of bond, we would ask that the court order that the defendant not have, possess or have any weapons in his possession. I would also ask that the court order no contact with the following individuals: Gaige Grosskreutz, Richard McGinnis, Dominic Black, as well as relatives of the victims in this case, including John Huber, who is here by Zoom, Karen Bloom, who is Anthony Huber's mother, and Charles Rosenbaum, who is a brother of the victim, Joseph Rosenbaum. Thank you.
All right, and Karen, did you say Bloom? Is that B-L-U-M or a different spelling?
I think it's B-L-O-O-M.
That's correct.
Okay, all right, thank you.
I heard the government's argument. Last time I checked, having went through an extradition hearing is not a valid basis to have a higher bond when one is only asserting one's constitutional right to have that hearing. Further, on the video, which this criminal complaint is based on, it's clear that the client, Kyle, tried to turn himself in to law enforcement. They chose not to accept his surrender. He went to the Antioch Police Department, where he was from. He turned himself in. He waited for the Kenosha Police Department to go there. The criminal complaint is full of material omissions, whether through negligence or through recklessness. It doesn't talk about Mr. Rosenbaum chasing my client while masked, covering his identity. It doesn't talk about Mr. Zeminski, his partner, firing the first shot at my client. When my client is running down the road trying to get away, he goes And Mr. Grosskreutz approaches him and goes, "Where are you going?" "Going to turn myself into the police," which he tried. It's on video. My client is 17 years old. He has no prior juvenile, no other record whatsoever. He has ties to the community. His father lives in the community. He worked in the community. The self-defense claim in this case is overwhelming. It's on videotape. And under all of those circumstances, $750,000 and electronic monitoring is more than sufficient. We have no objection to the non-monetary conditions, but at a certain point, the state can bury their head in the sand. And in reality, who struck my client first? Who attacked my client first? Mr. Rosenbaum, the decedent. My client's running down towards the police line when he's attacked by a mob. We're not talking about demonstrators. We're talking about rioters who had ill intent in their heart, and unfortunately, they came in second.
All right, thank you, Mr. Richards. Court's aware these are allegations, but they are the most serious of allegations. They're incredibly serious. And again, if a conviction occurs, and only obviously if a conviction occurs, the defendant would likely face either life imprisonment or an imposition of many decades. Oh, I'm sorry. Also, before I go further, though, I do want to hear from the victims, if I could, if they do wish to be heard in this part. Mr. Huber, do you wish to be heard, sir? You'll have to unmute yourself then, sir. Mr. Huber, you're on mute. Can you unmute your device?
Okay, can you hear me now?
I can, sir.
Okay, good afternoon, Your Honor. I would like to say that, this Kyle guy is a flight risk. He's facing long time in prison. And he has people out there that will help him. Organizations of militia members that are raising money for his defense right now. They can harbor him. He can
Your Honor,
hide
I'm going to
out in
object to
there.
this. There's no basis in fact or law.
Mr. Richards, that's Mr. Huber's opinion. He may state his opinion pursuant to the current status of the law in Wisconsin. I'm going to allow him to state that position. What I take into account may be different. But at this point, Mr. Huber is allowed to state his position as a victim in this matter. Go ahead, Mr. Huber.
Yeah, Kyle Rittenhouse thinks he's above the law. He's been treated as such by law enforcement. And so he believes he's justified in this case. And for him to run wouldn't surprise me. And this defense of self-defense, that is impossible. That is impossible. I don't know what part of the video you watched, but he already killed a guy, shot him in the head, and then tried to run. And my son was a hero. He tried to stop him. And so did everybody else. He was an active shooter, and he tried to flee. And my son lost his life protecting other people. He was a hero. And anyone who says otherwise is dead wrong, including the president, for to comment on that. How dare he? He needs to just stay on Twitter. He already admitted to killing 2 people in Antioch. He told the police, "I killed 2 white guys." Okay? So he's already admitted it. And, people buying him an assault weapon, they're responsible also. Who gives a kid an assault weapon? Says, "Oh, go to Wisconsin." This is what we're up against here. It's not about self-defense anywhere. And if you can double his cash bond, that's what I'm for. I'm for doubling his bond. It should be $4 or $10 million, because there's people out there raising money right now, making it their own fight, that it's about gun rights, and it's not about gun rights. My son was killed. Another man was killed. They didn't deserve to be killed. And we don't have that society where we just let people go and kill people and say, oh, you guys, we'll push them down there and you guys kill them down there. Because that's what the police did here. And the police weren't doing their job, or else they wouldn't have asked for these people to come around. You know, he was 2 businesses away when he chased that guy down and shot him in the head. That's far. He chased him down to kill him. And that guy was unarmed. And my son was unarmed. He hit him in the shoulder with a skateboard. You know, he was a hero. Anyways, that's all I have.
All right, thank you, Mr. Hubert. Mr. Grosskreutz, did you wish to address the court?
Your Honor, I'll address the court on behalf of Mr. Grosskreutz. Thank you very much. We do agree with what Mr. Huber has just said, that Anthony Huber was in fact a hero, and our condolences go to you. I think it's inexcusable, the behavior of Mr. Rittenhouse. We believe that he's a significant flight risk. We also believe that his bail should be set at a minimum of $4 million. We believe that he has shown himself to be a flight risk because even though he may have been running past police officers with his hands up, it didn't stop him from jumping in a car and then driving past numerous police stations that night when he could have turned himself in that night in the state of Wisconsin. And he failed to do that. We believe that Mr. Rittenhouse is a significant danger to the public as well. And we ask the court to impose a significant amount of bail. As Mr. Huber just indicated, there are numerous organizations and people that are raising money on behalf of Mr. Rittenhouse. My client has faced significant threats to his safety from numerous people. We're not attributing that to the defendant at all, but we are concerned that if he is released, that those threats will increase significantly. And so we ask the court to take all these things into consideration, the arguments of the state, as well as the arguments from Mr. Huber, and to impose at a minimum a $4 million cash bail. Thank you.
All right, thank you. All right. Now, well, as I said before, the charges are incredibly serious. And again, and only if conviction occurs, there would be a likelihood of an imposition of a mandatory life sentence or at least significant amounts of time, likely decades of time, period of incarceration. That is very concerning to this court. The issue for bail is to secure the defendant's appearance in court. In this case, that I note that, as I said before, the exposure is great. There's a report that Mr. Rittenhouse did flee the scene of the occurrence. He left the state, in matter of fact, was then involved in a contested extradition hearings to be returned to the jurisdiction of the Kenosha County. Mr. Richards is right, does have a right to contest extradition, but the issue that this court has to determine is what, pursuant to the statutes, are what issues are there with respect to the basis of whether or not Mr. Rittenhouse is a flight risk or not. Now, again, I don't feel that at this juncture, at this point in time, Mr. Rittenhouse has significant ties to Kenosha County. And as such, I believe that there's a reasonable basis to believe that a very significant cash bond is necessary to assure this defendant's appearance in court, as court does believe that he is a flight risk based upon the comments I just made. And in addition, the case is Mr. Richards has brought up, he did surrender himself to Illinois authorities, but circumstances appeared to have changed at some point following that with respect to the extradition issues. But again, that's not, this court doesn't take in it, hold it against Mr. Rittenhouse, if you will, in terms of exercising his constitutional rights in the state of Illinois. More to the point about whether or not Mr. Rittenhouse will appear as required in the state of Wisconsin in Kenosha County for court and court appearances. Court, as I said a minute ago, does believe that for the reasons stated, Mr. Rittenhouse is a flight risk. As such, court is going to impose a $2 million cash bond, believing that is reasonable and necessary and sufficient at this juncture to secure the appearance of Mr. Rittenhouse. In addition, non-monetary conditions are as follows, Mr. Rittenhouse. You're to have no contact with the following individuals: Now, that is no contact at any time, any location, for any reason, through any forum or means. That's with Richard McGinnis, Gaige Grosskreutz, Dominic Black, Karen Bloom, John Huber, or Charles Rosenbaum. In addition, sir, you may not possess any weapons of any type, especially firearms. You must appear in court every time when required here in Kenosha County if you are released. You may not commit further crimes while out on bond. Do you understand all of those conditions, Mr. Rittenhouse?
Yes, sir.
Thank you very much, sir. Now, my understanding that I'll speak to Mr. Richards. As you're aware, Mr. Rittenhouse has a right to have a preliminary hearing held by statute within 10 days of his initial appearance when you're held in custody on a felony case, as he is. There's some discussion off the record. I've been advised, I wasn't a participant to that, but that there's a likelihood that Mr. Rittenhouse, through Mr. Richards, wishes to waive the time to have and ask the court to toll time to calendar the preliminary hearing out beyond that 10-day statutory limit. Is that correct, Mr. Richards?
That is correct. I discussed with my client that yesterday, and he's in agreement.
All right, thank you. Mr. Rittenhouse, again, can you hear me clearly? This is the commissioner speaking.
Yes.
All right, thank you. Now, you have a right, sir, when you're held in custody in a felony case in the state of Wisconsin, to have a preliminary hearing held within 10 days of your initial appearance. Do you understand that?
Mm-hmm.
All right, but you also have the right, sir, to waive that time limit, allow this court and ask the court to toll time in order to schedule your preliminary hearing farther out or beyond that 10-day limit. Do you understand that as well, sir?
Yes, sir.
All right, that's what your attorney, Mr. Richards, indicates you wish to do. Do you understand that?
Yes.
Is that what, in fact, you do wish to do, sir?
Yes.
All right, thank you. Then based upon the defendant's understanding and willingness to waive time, the court will toll time for cause, in this case, pursuant to the request of the defendant and through his attorney, Mr. Richards, to counter the preliminary hearing out beyond the 10-day statutory limit.
Preliminary hearing, December the 3rd. Again, that's 12/3 at 10:30 a.m.
Works for me.
All right. Is there anything else? Otherwise, I'll conclude the hearing.
No, Your Honor. Thank you.
No, Your
All
Honor.
right, thank you. Thank you, everyone. That'll conclude the hearing.